Good evening, everyone, and welcome to more reading of Modern American Remedies. Again, I'd like to thank the musical brother Owen for that great musical riff intro. He's the man. Check him out wherever you can find him. He's great. Additionally, a programming note, sort of, I am sick as hell. So if I'm coughing and hacking up stuff and blowing my nose at any point in time, or if I sound a little bit nasally or odd, that's why. But the law waits for no man. We gotta bear with it and keep going. So, all right. So today we are reading from Modern American Remedies, the controversy over tort law, the case Arbino versus Johnson and Johnson, Ohio case from 2007. Melissa Arbino sued Johnson & Johnson in federal court, alleging that she suffered blood clots and other serious side effects caused by the Ortho-Evra birth control patch. The federal judge certified to the Ohio Supreme Court the question of whether the limit on non-economic damages in Ohio Revised Code annotated section 2315.18 violates the Ohio Constitution. Justice Moyer gave the opinion. 2. Tort reform in Ohio and state in stare decisis. Since 1975, the General Assembly has adopted several so-called tort reform acts. In Morris v. Savoy in 91, which held a $200,000 cap on general damages in medical malpractice cases not involving death, with no exceptions for the most severe injuries, violated the due process protections of the Ohio Constitution. We specifically noted that it is irrational and arbitrary to impose the cost of the intended benefit to the general public solely upon a class consisting of the most severely injured by medical malpractice. In Sorrell v. Fenever, a 1994 decision, Ohio Supreme Court, we held that mandatory deduction of collateral source benefits violated the right to a jury trial, due process, equal protection, and the right to a remedy. In Galeta v. Lake Hospital System Incorporated, a 94 case, we invalidated a statute that required trial courts to order awards of future damages in excess of $200,000 and medical malpractice actions to be paid in a series of periodic payments upon the motion of any party. In Zoppo v. Homestead Insurance Company, a 94 case, the statute required a trial judge to determine the amount of punitive damages to be awarded in a tort action, even when the trier of fact was a jury. We struck this section as a violation of the right to a jury trial. In 1997, the legislature passed a wide-ranging bill to limit tort recoveries. This bill changed over 100 sections of the Ohio Revised Code, contained 18 titles and 38 chapters. We held that this act violated the separation of powers and the single subject clause of the Ohio Constitution. Stat Ex Rel. Ohio Academy of Trial Lawyers versus Sheward, a 1999 Ohio Supreme Court decision. The protracted interbranch tension on the subject establishes at least two key points. First, tort reform has been a major issue of concern in the state over the past several decades and remains one today. State legislatures and judiciaries have differed widely in their responses to the issue. Second, our prior review has focused on certain unconstitutional facets of the prior tort reform laws that can be addressed to create constitutionally valid legislation. All right. Standard of review. Limits on non-economic damages. A. The statute does not apply to tort actions against government entities or to actions for wrongful death, medical or dental malpractice, or breach of contract. In all other tort actions, it requires a finder of the fact to specify both the total compensatory damages recoverable by the plaintiff and the proportions of those damages representing economic and non-economic losses. Economic loss is defined as lost income, medical expenses, and any other expenditures incurred, not including attorney's fees. Non-economic loss is defined as non-pecuniary harm, including, but not limited to, pain and suffering, loss of society, consortium, companionship, care, assistance, attention, protection, advice, guidance, counsel, instruction, training, or education, disfigurement, mental anguish, and any other intangible loss. Ohio State Revised Statute 2315.18a sub 4. The court must enter judgment for the plaintiff for the amount of economic damages without limitation as determined by the trier of fact. For non-economic damages, the court must limit recovery to the greater of either 1, $250,000, or 2, 3 times the economic damages up to a maximum of $350,000 per person, or $500,000 total for a single occurrence. However, these limits on non-economic damages do not apply if the plaintiff suffered, quote, permanent and substantial physical deformity, loss of use of a limb, or loss of a bodily organ system, or permanent physical, functional injury that permanently prevents the injured person from being able to independently care for self and perform life-sustaining activities. Same section under B sub 3. The right to a jury trial. The right to a trial by jury protects the plaintiff's right to have the jury determine all the issues of fact in his or her case. Because the extent of damages suffered by a plaintiff is a factual issue, it is within the jury's province to determine the amount of damages to be awarded. Any law that prevents the jury from completing this task or allows another entity to substitute its own findings of fact for the jury's is unconstitutional. We reaffirm this principle in Sorrell by striking down a statute that required a court to determine any collateral benefits received by a plaintiff and deduct them from a jury award, regardless of whether those benefits were duplicated in the award. The statute was unconstitutional because it allowed courts to ignore the jury's finding of facts on collateral benefits. So long as the fact-finding process is not intruded upon and the resulting finders of fact are not ignored or replaced by another body's findings, awards may be altered as a matter of law. Thus, without violating the Constitution, a court may apply the law to the facts determined by a jury. We have recognized several ways in which a court may apply the law to change a jury award of damages without running afoul of the Constitution. For example, courts have had the inherent authority to order remitterers to reduce jury awards when they deem the amount to be too excessive. Numerous statutes, treble jury damage, which means 3 times, treble is like triple, jury damages, awards in certain causes of action. We have never held that the legislative choice to increase a jury award as a matter of law infringes upon the right to a trial by a jury. The corresponding decrease as a matter of law cannot logically violate that right as well. Section 2315.18 of the Ohio Revised Code is distinguishable from those allowing courts to substitute their own findings of fact on collateral benefits or requiring repayment plans that further reduce the jury's award of damages already once reduced to the present value. That's from the Glada decision at 301, page 301. Courts must simply apply the limits as a matter of law to the facts found by the jury. They do not alter the findings of fact themselves, thus avoiding constitutional conflicts. Such limitations are also permissible under the analogous 7th Amendment right to a jury trial in the federal system. Quote, federal courts uniformly have held that statutory damage caps do not violate the 7th Amendment, largely because a court does not re-examine a jury's verdict or impose its own factual determination regarding what a proper award might be. That's from the estate of Sisk versus Manamares, a 2003 federal case. Second District. Because Ohio Revised Statute 2315.18 follows these principles, it does not offend the right to a trial by jury under the Ohio Constitution. Point 2. Open courts and a right to a remedy. The Constitution provides, quote, all courts shall be open, and every person for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law, and shall have justice administered without denial or delay. The Ohio Constitution, Article 1, Section 16. We have interpreted this provision to prohibit statutes that effectively prevent individuals from pursuing relief for their injuries. See Brenneman versus RMI Corporation, a 94 Ohio case, finding that a statute of repose unconstitutional because it deprives certain plaintiffs of the right to sue before they were aware of their injuries. Although Section 2315.18 Ohio statute does not limit certain types of non-economic damages, or does limit certain types of non-economic damages, those limits do not wholly deny persons a remedy for their injuries. Injured persons not suffering the catastrophic injuries listed in 2318.18b sub 3, for which there are no damage limits, may still recover their full economic damages and up to $350,000 in non-economic damages, as well as punitive damages. These available remedies are meaningful ones under the Constitution. While the statute prevents some plaintiffs from obtaining the same dollar figure they may have received prior to the effective date of the statute, it neither forecloses their ability to pursue a claim at all, nor completely obliterates the entire jury award. That's quoting from the Sorrell decision. Section 3. Due course of law / due process. Arbino's next challenge to 2315.18 also arises from Section 16, specifically the due course of law provision. We have recognized this provision as the equivalent of the due process of law protections in the United States Constitution. When reviewing the statute on due process grounds, we apply a rational basis test unless the statute restricts the exercise of fundamental rights. Because we have already concluded that Section 2315.18 violates neither the right to a jury trial nor the right to a remedy, we must find it valid under the rational basis test. if 1, it bears a real and substantial relation to public health, safety, morals, or the general welfare of the public, and 2, it's neither unreasonable or arbitrary. That's from Momini versus Sauerbreath, a 1986 Ohio Supreme Court decision. Subpoint A, real and substantial relation to the general welfare of the public. The record here reveals that the General Assembly reviewed several forms of evidence and made numerous findings relative to Section 2315.18 in an uncodified section of SB 80, Senate Bill 80, which made this code passed in Ohio. It found that the current state of the civil litigation system represents a challenge to the economy of the state of Ohio. This finding was supported by 1, National Bureau of Economic Research studies showing that states adopting tort reforms experience growth in employment, productivity, and total output, and 2, a 2002 White House Council on Economic Advisor study equating the cost of tort litigation to a 2.1% wage and salary tax, a 1.3% personal compensation tax, and a 3.1% capital investment income tax. A Harris poll of 928 senior corporate attorneys showing that the litigation environment in the state greatly affected the business decisions of their companies. 4, a Tinghast Towers parent study showing that the tort system failed to return even 50 cents for every dollar to injured plaintiffs, and that the cost of the national tort system grew at a record rate in 2001, with a cost of equivalent to a 5% tax on wages. And 5, testimony from the Ohio Department of Development Director Bruce Johnson on the rising costs of the tort system, which he believed were putting Ohio businesses at disadvantage and hindering development. In addition to these general economic concerns, the General Assembly noted that non-economic damages are difficult to calculate and lack a precise economic value. It further concluded that such damages are inherently subjective and susceptible to influence from irrelevant factors, such as defendants' wrongdoing. It also recognized the inflated damage awards were likely under the then current system and that the cost of these awards was being passed on to the general public. Viewing these findings as a whole, we conclude that 2315.18 bears a real and substantial relation to the general welfare of the public. Arbino challenges the persuasiveness of these findings and argues that the crisis proposed by the evidence is non-existent. In doing so, she asks us to evaluate information relied upon by the General Assembly and come to our own conclusions as to whether Section 2315.18 was warranted. Such intensive re-examination is beyond the scope of our review. Quote, we are to grant substantial deference to the predictive judgment of the General Assembly under a rational basis review, quoting from State v. Williams, a 2000 Ohio Supreme Court case. Finding that the General Assembly's review of the evidence yielded a statute that bears a real and substantial relation to the general welfare of the public, we do not need to cross-check its findings to ensure we would agree with its conclusions. Subpoint B, neither arbitrary nor unreasonable. The second prong of the rational basis test asks whether the statute is arbitrary or unreasonable. In Morris, we found that the damage cap violated this prong because they imposed the cost of the intended benefit to the public solely upon the most seriously injured. Section 2315.18 alleviates this concern by allowing for limitless non-economic damages for those suffering catastrophic injuries. Arbino suggests that even with this exception for catastrophic injuries, the non-economic damage limitations remain unreasonable and arbitrary. She argues further that it is irrational to strike a statute for imposing the cost of a public benefit on the most severely injured, but not the second most severely injured class of people. At some point, though, the General Assembly must be able to make a policy decision to achieve a public good. Here, it found that the benefits for non-economic damages limits to be obtained without limiting the recovery of individuals whose pain and suffering is traumatic, extensive, chronic, and by setting the limits for those who are not as severely injured at either $250,000 or $350,000. Even Arbino acknowledges that the vast majority of non-catastrophic tort cases do not reach that level of damages. The General Assembly's decision is tailored to maximize benefits to the public while limiting damages to the litigants. The logic is neither unreasonable nor arbitrary. 4. Equal protection. The Ohio Constitution states, quote, all political power is inherent in the people. Government is instituted for their equal protection and benefit. Ohio Constitution, Article 1, Section 2. We have interpreted this provision as the equivalent of our Federal Equal Protections Clause. A. Standard of review. In arguing for strict scrutiny, Arbino alleges that Section 2315.18 infringes on both a fundamental right, the right to a jury trial, and the rights of suspect classes. She specifically claims that damages caps disproportionately affect women, children, minorities, the elderly, and people with low incomes. We rejected the fundamental right argument in Section 3A1 above. Further, even if we accepted Arbino's contention that the non-economic damage caps disproportionately affect certain classes, facially neutral laws that may have such an impact do not violate the Equal Protections Clause. Finding Section 2315.18 to be facially neutral, we apply the rational basis test. B. Rational relationship to a legitimate government purpose. The limitations on non-economic damages awards in certain tort actions in Section 2315.18 certainly create distinctions between different groups of people. In setting a cap at either $250,000 or $350,000 for non-economic damages for certain injuries and no caps on others, the statute treats those with lesser injuries, i.e., those not suffering injuries designated in 2315.18b sub 3, differently from those most severely injured. We cannot say that the General Assembly's action lacked all rational relation to any legitimate state interest of improving the state's civil justice system and its economy. The limitations were aimed at reducing uncertainty associated with the existing tort system and the negative consequences resulting from it. The distinctions the legislature drew in refusing to limit certain injuries were rational and based on the conclusion that catastrophic injuries offer more concrete evidence of non-economic damages, and thus calculation of those damages poses a lesser risk of being tainted by improper external considerations. That reasoning withstands scrutiny under the rational basis test. 5. Separation of powers. The argument that Section 2315.18 infringes on the judicial power to decide damages lacks merit. It is certainly a judicial function to decide the facts in a civil case, and the amount of damages is a question of facts. However, that function is not so exclusive as to prohibit the General Assembly from regulating the amount of damages available in certain circumstances. 4. Conclusion. The decision in this case affirms the General Assembly's efforts over the last several decades to enact meaningful tort reforms. It also places Ohio firmly with the growing number of states that have found such reforms to be constitutional. However, the issue remains a contentious one across the nation, with several states finding statutes unconstitutional. Using a highly differential standard of review appropriate for a facial challenge to these statutes, we conclude that the General Assembly has responded to our previous decisions and has created constitutionally permissible limitations to tort damage recovery in Ohio courts. Judge Lundberg, Stratton, O'Connor, and Langizer concurring. Justice Cupp concurring as well, but separate opinion. It is long settled constitutional law that it is within the power of the legislature to alter, revise, modify, or abolish the common law as it may determine necessary or advisable for the common good. The power to alter or abolish a common law cause of action necessarily includes the power to modify any associated remedy. The legislature's substantive lawmaking power is not limited by the right to a jury trial, provided the litigant retains that right to have the jury determine the amount of damages to the extent the damages are legally available. Legislative action, however, may alter or limit what damages the law makes available and legally recoverable. Lundberg, Stratton, O'Connor, and Lanzer concur in the foregoing opinion that Cupp wrote. We have O'Donnell dissenting in part. O'Donnell says, a remitterer differs fundamentally from a cap on non-economic damages imposed by Section 2315.18. A remittitor is based on the judicial determination that a particular verdict is excessive and plaintiff must be offered a choice of remitterer or a new trial. Section 2315.18 does not resemble remitterer in any of these respects. It is arbitrarily establishes without consideration of any facts in any particular case that the jury's award for non-economic damages is excessive when it exceeds the statutory limit. More important, the statute reduces such a verdict without the consent of the party in whose favor the verdict was returned. A statutory damage multiplier increases the damages found by a jury with respect to a statutory cause of action in keeping with the punitive nature of the legislation. This has no similarity to Section 2315.18, which applies to common law causes of action and precludes a court from entering a judgment on a jury finding regarding compensatory damages. The court essentially is saying that the right to trial by jury is not invaded if the jury is allowed to determine facts which go unheeded when the court issues its judgment. Such an argument pays lip service to the form of the jury, but robs the institution of its function. Quoting from Selfie versus Firebrand Corporation, a 1989 Washington Supreme Court case, emphasis added. Justice Pfeiffer also dissented, but didn't write a separate opinion. And that's the case for the day, peoples. Now we also have because it's referenced so much, and our professor printed it out and told us to read it. We have Section 2315.18 of the Ohio Revised Code of 2021. Compensatory damages in tort actions. Factors excluded. Findings on interrogatories is the title of this. So it's Title 23, Courts of Common Pleas, Chapter 2315, Trial Procedure, Section A. As used in this section and in Section 2315.19 of the Revised Code, asbestos claim has the same meaning as Section 2307.91 of the Revised Code. Economic loss means any of the following types of pecuniary harm. A. All wages, salaries, or other compensation lost as a result of an injury or loss to a person or property that is subject to a tort action. B. All expenditures for medical care, treatment, rehabilitation services, or other care, treatment, services, products, or accommodations as a result of an injury or loss to a person or property that is subject of a tort action. C. All other expenditures incurred as a result of an injury or loss to a person or property that is a subject of a tort action, other than attorney's fees occurred in connection with the action. 3. Medical claim, dental claim, optometric claim, and chiropractic claim have the same meanings as in Section 2305.113 of the Revised Code. Non-economic loss means non-pecuniary harm that results from an injury or loss to a person or property that's subject to a tort action, including but not limited to pain and suffering, loss of society, consortium, companionship, care, assistance, attention, protection, advice, guidance, counsel, instruction, training or education, disfigurement, mental anguish, or any other intangible loss. Occurrence means all claims resulting from or arising out of any one person's bodily injury. 6. Product liability claim has the same meaning as Section 2307.71. 7. Tort action means a civil action for damages for injury or loss to a person or property. Tort action includes a civil action upon a product liability claim or an asbestos claim, a civil action based on unlawful discriminatory practice relating to employment brought under Section 4112.052 of the Revised Code, and a civil action brought under Section 4112.14 of the Revised Code. Tort action does not include a civil action upon a medical claim, dental claim, optometric claim, or chiropractic claim, or a civil action for damages for breach of contract or another agreement between persons. Trier of fact means a jury or a non-jury action to court. B. A tort action to recover damages for injury or loss to person or property, all of the following apply. B sub 1. There shall not be any limitation on the amount of compensatory damages that represents the economic loss of the person who is awarded the damages of the tort action. B2. Except as otherwise provided in Division B3 of the section, the amount of compensatory damages that represents damages for non-economic losses recoverable in the tort action under this section to recover damages for injury or loss to person or property shall not exceed the greater of $250,000 or an amount that is equal to 3 times the economic loss as determined by the trier of fact, or of the plaintiff in the tort action to a maximum of $350,000 for each plaintiff in that tort action, or a maximum of $500,000 for each occurrence that is the basis of that tort action. B3. There shall not be any limitation on the amount of compensatory damages that represents non-economic loss that's recoverable in tort action to recover damages for injury or loss to person or property if the non-economic losses of the plaintiff are either of the following. B, subpoint 3, subpoint, or a little a underneath that. So any of the following. Permanent or substantial physical deformity, loss of use of a limb, or loss of a bodily organ system. B3 sub B, B, subpoint 3, little b. Permanent physical functional injury that permanently prevents the injured person from being able to independently care for self or perform life-sustaining activities. So B3 little c, or big C. In determining an award of compensatory damages for non-economic loss in a tort action, the trier of fact shall not consider any of the following. Evidence of the defendant's alleged wrongdoing, misconduct, or guilt, evidence of the defendant's wealth or financial resources, all other evidence that is offered, all other evidence is offered for the purpose of punishing the defendant rather than offering a compensatory award. 8 big D. If a trial is conducted in a tort action to recover damages for injury or loss to a person or property, and a plaintiff prevails in an action, the court in a non-jury trial shall make findings of fact, and the jury in a jury trial shall return a general verdict accompanied by answers to interrogatories that shall specify all the following. Big 8, big D, little 1. The total compensatory damages recovered by the plaintiff. Little 2. The portion of the total compensatory damages that represents damage for economic loss. Little 3. the portion of the total compensatory damages that represents damages for non-economic loss. Little e, big 1. After the trier of fact in the tort action to recover damages for injury or loss to person or property complies with Division D, the one we just read of the section, the court shall enter judgment in favor of the plaintiff for compensatory damages for economic loss in the amount determined pursuant to Division D2 of the section and subject to Division F1 of the section. The court shall enter a judgment in favor of the plaintiff for compensatory damages for non-economic loss, except as provided in B3 of the section. In no event shall a judgment for compensatory damages for non-economic loss exceed the maximum recoverable amount that represents damages for non-economic loss as provided in B2 of the section. That's a $250K or $350K. Division B of the section shall be applied to a jury trial only after the jury has made its factual findings as determination to the damages. 8E2, 8, 8E1, 2, E little 2. Prior to the trial in the tort action described as Division D of the section, any party may seek summary judgment with respect to the nature of alleged injury or loss to person or property, seeking a determination of the damages as described in Division B2 of the section. 8, big F, 1. A court of common pleas has no jurisdiction to enter judgment on the award of compensatory damages for non-economic loss in excess of the limits set forth in the section. F2. If the trier of fact is a jury, the court shall not instruct the jury with respect to the limit on compensatory damages for non-economic loss described in Division B2 of the section, and neither counsel for any party nor a witness shall inform the jury or potential jurors that there is such a limit. G. With respect to a tort action with Division B2 of the section applies, any excess amount of compensatory damages for non-economic loss that's greater than the applicable amount specified in Division B2 of the section shall not be reallocated to any other tortfeasor beyond the amount of compensatory damages that the tortfeasor otherwise be responsible for responsible under the laws of the state. H. The section does not apply to any of the following. H1. Tort actions that are brought against a state in the court of claims, including but not limited to those actions in which a state, university, or college is a defendant and of which Division B3 of Section 3345.40 of the Revised Code applies. Or H2. Tort actions that are brought against political subdivisions of the state and that are commenced under or are subject to Chapter 2744 of the Revised Code. Division C of Section 2744.05 of the Revised Code applies to recoverable damages in those actions. H3. Wrongful death actions brought pursuant to Chapter 2125 of the Revised Code. I. If the provisions regarding the limits on compensatory damages for non-economic loss set forth in Division B2 of this section have been determined to be unconstitutional, then Division C of this section in Section 2315.19 of the Revised Code shall govern the determination of award for compensatory damages for non-economic loss in any tort action. There was that. That's this Ohio Revised Statute 2315.18 A through I. That was a subjective issue in that case. Well, sports fans, that's it for Remedies tonight. I hope you all sleep well. Make sure to tip your waitresses, tip your serving staff, tip your bartender. Don't drive drunk. Wash behind your ears, eat your vegetables, and listen to your mama as long as she's not talking shit. See y'all tomorrow or later on, or see you next time.